All right, let's go. Cisco is ordered by the U.S. District Court of Virginia to pay $1.9 billion to Centripetal Networks Incorporated in what may be the largest patent infringement damages award ever. All this and more on Stuff You Should Know About IP. Okay, so Tom, please explain to me this case of Centripetal Networks Inc. versus Cisco, and how did we get to $1.9 billion in damage? That's crazy.
Yeah, it's crazy. What a great way to start the day, right?
Oh, yeah.
Great way to start the day is talking about an almost $2 billion patent verdict, right?
And a cup of Tim Hortons coffee.
Of course, of course. So anyway, so we have this, I'm going to sneeze. Should we start over?
No.
Okay.
We should definitely put a copyright on that sneeze, though.
Okay. So anyway.
Well, actually.
Anyway, the biggest verdict of all time, Centripetal against Cisco, just occurred. Now, by the way, a few interesting things about this. Number one, it was 1.9 billion, right?
Billion.
Two, there was royalty payments on top of that, which are 10% for the first 3 years, 5% for the next 3 years. So the claim is that this thing could be like a $2.5 to $3.5 billion verdict all in. But so here are some interesting things about it. Number one, there's 5 patents in the suit. 4 of them were found to be literally infringed. So that's what gets us started. This case started in February of 2018. And a few things jump out in my mind. So it's like almost 3 years, right? Mm-hmm. Imagine how many lawyers have been feeding off this case for 3 years, right?
Yeah. It's almost like they'd be sad to see it come to a close.
Oh yeah. I mean,
what do we do with ourselves now?
Yeah, one side is, I don't know whether the plaintiff's firm took it on a contingency. If they did, they'd be pretty excited. Could you imagine a third of 1.9 billion for your firm?
Do firms take cases like this on contingency?
Well, contingency.
I don't want to distract from the topic.
But no, that's okay.
I never heard of that.
Cases are typically the thing of personal injury lawyers, right?
Yeah, that's what I thought.
But in the 90s, and I might have my dates wrong, I might have the facts slightly off, but the concept is in the 90s, there was this law firm, a patent firm, I think it was in Chicago, that was offered to take the case on a contingency basis, and they said no. They ended up earning $3 million in fees. The verdict was $100 million. So they would have gotten $30 million in fees.
Yikes.
So after that, they switched to all like contingency cases. So there are definitely firms out there that take these cases on a contingency, and this would be a great example of one that would want to. But the trade-off though is, here's the trade-off though. The nice thing about getting your fees, which in these cases are maybe $600, $700, $800 an hour, maybe $900 an hour, depending upon where the lawyers are, maybe more. The nice thing is you're getting paid for 3 years. You're getting paid, you're paying your associates. There's got to be, a dozen people on this case.
Yeah.
You have paralegals, you have lawyers that all need to be paid. And if your firm isn't well heeled with big pockets, deep pockets, you're not going to be able to support a 3-year litigation with all these people not getting paid. So, I mean, maybe it's bankable. Maybe you can go to a bank and get loans. But anyway, the point is, there's a great value if you can do them on a contingent. But what if after 3 years you lose and you get no cause? Now you're totally screwed. But anyway, so lawyers are feeding off this case, and here's the sad thing for Cisco, okay? In addition to, they were willful infringers, so maybe it's not that sad, but here's the sad thing. They spend millions on defense of this patent infringement case, right? Millions. And at the end of it all, they lose. And they end up paying out almost $2 billion or more when you include the royalties. So it's this patent litigation game, it used to be referred to as the sport of kings, because it's so expensive, which is why it doesn't surprise you that these cases typically settle, because it's such a high stakes game, right? You're talking about years of litigation, and yeah, it could be a $2 billion verdict, which is great for one side, terrible for the other.
Yeah.
But it could be a no cause, which then is pretty good for one side, terrible for the other. I say pretty good because if there's a no cause and Cisco were to win and they said there was no infringement, then yeah, they're thrilled that they staved off this big, ugly verdict, but they still had to pay a fortune in legal fees, still be distracted for 3 years, still have this black cloud hanging over their head. So if you're a defendant in a patent case, there's no way to win. I mean, your best case scenario is to spend a shit ton of money on legal fees, and then you still have to, you win, you get to just do what you were doing before.
Right.
So anyway, so that's interesting. The other thing that they went out of their way to say in this article was that the court held, in favor of the plaintiff by a preponderance of the evidence, which is just kind of a side note to say that these cases are not beyond a reasonable doubt. They're a preponderance of the evidence, which is essentially more likely than not. So, it's like if you were giving it percentages, it's like 51%, right?
Right.
It's not like 90%, which you would kind of assess to beyond a reasonable doubt. It's like 51%. The other big thing in this is that they used a royalty system on top. So how do you assess a royalty? When you're talking about, if you're buying a house, it's kind of easy to get comparables, right? I'm buying a house in a neighborhood and 10 other houses have sold in the past 5 years or 5 months, and they were all about this price, and that means mine is worth a little bit more, a little bit less, right?
Right.
How do you do that when you're assessing reasonable royalties in a patent infringement case? Luckily, in this case, and I say luckily for the sake of Centripetal, they had just negotiated a deal with a company called Keysight, and that deal was a lump sum payment of $25 million plus a 10% royalty over the first 3 years for competitive sales of competitive products, and then 10%, then 5% for royalties based upon the sales of non-competitive products.
Right.
Now, the difference there was with the Keysight settlement. By the way, I'm just turning this because I feel like I'm not lit up that well. But
yeah, it's a little dark. If
dark.
you tilt it down a little bit, it might be better. Tilt your camera down.
Yeah, maybe that's better. But anyway, so in this Keysight case, the difference was Keysight took a license to the entire Centripetal portfolio. In this case, it's only 4 patents. So, and I don't know the size of the portfolio, but let's say it's 50 patents or 20 patents. It's certainly a lot more than 4 patents in the Cisco case. So they ended up coming up with 10-year or 10% royalty for 3 years on all products that infringe these patents, and then 5% for the next 3 years. This is a lot of money.
Yeah.
So the other interesting thing is, yes, it's 1.9 billion, right? But the damage award was not 1.9 billion. The actual damages were like 700 million or something, right? 700 million. But so 700 million turns into 1.9 billion, right? How does that happen? Well, there's this thing called, it used to be called treble damages based upon willful infringement. In like 2016, the U.S. Supreme Court changed it a little bit. They call it enhanced damages, and they don't have the same restrictions that they used to have. But without boring people to death with the details, it's still you can triple damages for willful infringement.
Right.
And what willful infringement? You knew about it and you infringed anyway.
Right.
So a lot of times what companies will do is they'll get opinions of non-infringement from their legal counsel so that they could use that to defend themselves in a case of patent infringement. We knew about the patents maybe, but our lawyer told us we didn't infringe. And that's big because it just turned a $700 million damages case into almost $2 billion, right?
That's crazy.
Now, in this case, I just read a little bit of an article about this, and it said there were discussions between Centripetal and Cisco under NDA where technology was disclosed by Centripetal to Cisco, And that created a situation where Cisco clearly knew about it. So they basically said that they knew about it, they infringed anyway, and that really offends courts, right? Because you knew about it. It's not like, I mean, there's a zillion patents out there, right? I mean, there are, millions of patents out in the world. And I don't know what the numbers are up to now, but they're pretty high. So imagine, how do you know every single patent out there and whether you're infringing it? Well, good news is if you don't know about it, you can't be hit with, enhanced damages like this because you didn't know. The bad news is, regardless of whether you knew about it, if you are an infringer, you are an infringer and you're going to pay.
Right.
So what some companies do is they do these things called freedom to operate searches, which essentially are searches before you go to market, before you commercialize, to determine whether there's any patents out there that are going to sting you when you get to market, right? Whether you're going to be infringing any of these. So people spend a fairly, large sum of money, which they should, because if you're going to spend, millions launching a new product, wherever you are in the world, it's worth it to spend, 5, 10, 15, 20,000 on a freedom to operate search to make sure you're not going to be infringing someone. The downside of freedom to operate searches is if you discover a patent that you're infringing and you do it anyway, you're at risk of enhanced damages. The plus side of doing a freedom to operate search is if you know about it, at least you can make an informed decision, right? Because you cannot use as an excuse, I didn't know about it, right? You can't, that's not an excuse in patent infringement.
So that's an interesting question that I had is, I mean, in this case, we know that Cisco knew about it because they had that information related to the patents disclosed to them by Centripetal under NDA.
Right.
But I mean, that's such an egregious infringement. Then I can understand how the court came to the decision on the judgment. But what about other cases where willfulness is maybe assumed or even implied or inferred, but not easily provable?
Yeah, if it's not, I mean, that's a big question is, can you prove it? Can you prove they knew? I was litigating a patent case once, and I'm in the deposition with the other side. So we're suing them for patent infringement. And I didn't even expect this. I asked the engineer, tell me how you developed your product. And because he was an honest guy, he doesn't know all about the legal ins and outs. He just said, I found this patent and, and I thought, wow, he just admitted to willful infringement, but he doesn't even know he did. So I got my mouth shut and moved on. Luckily,
was that in a deposition, did you say?
Deposition, yeah. Luckily, I was against a non-registered patent lawyer, in the litigation. I don't even think he knew what hit him at that point. The point is, it's usually not that obvious, right? And I had one case once, I had a copyright infringement case where it was, it was a patent infringement case. And the guy didn't say he copied the patent, but he said, oh, I just bought their product and I copied it. And, that's a little bit less because you don't know if something's patented unless it's marked, right?
Sure.
Unless you do a search. But anyway, so in this case, there's I didn't see the documentation on it, but there must have been some pretty compelling evidence to justify 2.5 times the damage award to get them up to like almost $2 billion.
There was something else I read in this article, and then we can move on. But there's something else that stood out to me that I don't think I fully understood, and maybe it's not as much of a thing as I read it to be. But was something about literally infringed was a term used, and it was literally infringed. It was all of the claims. So that made me curious about infringement, and I guess made me ask myself the question: are there varying degrees of infringement? Like if a patent has 5 claims and you violate 1, do you have to pay less for infringing one claim as you would 5 claims? Like, is that a thing or no?
Yeah, essentially. So imagine a patent document, right? You've got like, maybe it's this thick, it's like 50 pages or 100 pages or 20 pages. At the very end of the document are these things called claims. And the claims are essentially the inventor claiming his or her rights, defining the property right that's being owned, my piece of property, my house is on a lot that's 200 feet in the front, 200 feet in the back, and 500 feet along each side. That's my property right. And if you step on it, if you come over, you're trespassing. The claim is the same way. It's basically defining the metes and bounds of your invention. I own this. This is mine. I own a chair. You're an apparatus for sitting comprised of a back, a seat, and one or more legs. So let's say, though, that in my patent document, I have 3 or 4 or 5 independent claims, and then I've got maybe a dozen dependent claims. So I have a total of like 15 or 20 claims in my patent. All you have to do is infringe one claim, and you've infringed my patent, right? One claim, and you've infringed my patent. In this case, they didn't infringe 4 claims of one patent. They infringed 4 separate patents. Okay, so there was a total of 5 in the lawsuit. So they went and discovered at least one claim in each of those 4 patents that was infringed by Cisco. And now, without getting into like too much legal, detail, gory, ugly detail, there is something called literal infringement, which means that essentially, in lay speak, you are practicing. You have a product or service in the marketplace that contains each and every element of at least one claim in your patent. And let's simplify this. An apparatus for sitting comprised of a back, a seat, and 4 legs. Literal infringement is if I have an apparatus for sitting, a chair in the marketplace that has a back, a seat, and 4 legs. If I do, I'm literally infringing. And by the way, if I have a chair that has 3 legs, a back, a seat, and only 3 legs, I'm not infringing because I don't have 4 legs on my chair.
But if you have 5 legs, you're infringing because
exactly
4 is part of 5.
Yeah, because I still have 4, right? I could have 10 legs, and it might be cool. It might be a great invention, and it might be in and of itself patentable, right? But it doesn't give me the right to make, use, sell, or offer to sell it in the marketplace where I have the patent because I still have 4 legs.
So in a sense, if I dumb this down even more, it means that
that's pretty dumb, though, isn't it?
I mean, that was, yeah, well, hey, if I can understand it, then that means it's pretty dumb. But I
disagree with that, by the way.
Well, I got to go to law school first, but yeah. But if basically it means that they copied the product. I mean, not even like they with variation.
Exactly. Yeah, not exactly. And here's what I mean. Many people have patents and they also have products, right? I mean, unlike a trademark, you don't have to have a product in the marketplace to have a patent. With a trademark, as you know, trademarks go together like, peanut butter and jelly. Well, maybe not peanut butter and jelly. They're even tighter than peanut butter and jelly. And that is, if you do not have a product or service in the marketplace, with that trademark, you don't have a trademark, because trademarks are all about the, representing a product or service. A patent, though, is not the same. A patent, you could have a patent and never have a product and still sue a company for patent infringement.
Right.
Still get a $1.9 billion verdict, But the question, though, what your thing is, did they copy the product? Well, you could have a patent and you could have a product, and the two they're not, you might have.
Right.
So I have a patent on a chair with a back, a seat, and 1 or more legs, right? All I sell in the marketplace are stools, a back and a seat, and no leg. You're one leg, right? Because 1 leg doesn't infringe 4 legs, right? I might have a whole product suite that is not covered by my patent. So even though I have a patent on chairs with a back, a seat, and 4 legs, you go to the marketplace and you find all my three-legged chairs and you copy one, you're not infringing even though you've copied my product. I mean, you can copy anyone's product anytime and go to market. The only thing that prevents you from doing that is intellectual property, you know, or business factors, but intellectual property is the only thing that legally prevents you from doing that. So what do you have? You see somebody has a product in the marketplace. First question is that thing any good? And do I want to copy it? And if the answer is hell yes, that's a great product, I can make a lot of money. Then you got to ask yourself, is there some reason I can't copy it beyond my physical or mental or financial capabilities? Is there a trademark preventing me from copying it? Well, maybe if the product has a cool trademark, I can copy the product, but not the trademark, right?
Right.
Is there a trade secret protecting it? Well, Jimmy cracked corn and I don't care, because if I found out about it legally, if I reverse engineered it, if I discovered it legally, I can copy a trade secret in product, because trade secrets are only as valuable as your ability to keep them secret.
Yep.
3, is there a copyright? Well, if it's a product, probably doesn't relate to copyrights, right? I mean, maybe the marketing material or stuff around it. Then is there a patent, right? That's then the big question. How do you know that? Go do a freedom to operate search.
Yep.
You find a patent. Then you have to ask yourself, okay, I want to copy their product. Can I still do that? Well, I look at their patent and I'm like, wow, their patent doesn't even cover their own product. You know, they patented a seat having, or I mean, a chair having a back, a seat, and 4 legs. All their products are 1-legged, 2-legged, and 3-legged, right? I could copy all their products to my heart's content, because you can't infringe a product. You can only infringe patents, right?
Yep.
So that's kind of a long-winded response to your question of, do they actually have to go out and copy the product? And that doesn't mean infringement.
Yeah. No, that's really interesting. I'm actually glad I asked the question, because it was my way of thinking about it was like inverted. So that's really interesting. Yeah.
Yeah. So anyway, so that is Cisco and Centripetal, and I'm sure Centripetal is celebrating, and Cisco is doing something less than celebrating.
Yeah. Well, that's another like really big question that I have is, I mean, what? It's not so much a question as it is a statement. I mean, this kind of settlement, or it's not a settlement, but damages award could totally cripple even a business the size of Cisco. I mean, it could do really big damage to a big company.
Yeah. Now Cisco, though, I think they generate like what? Didn't you take a quick look?
It was like 49 billion in revenue.
Right. And then what's their profits?
Google told me it was 0.1 billion in let me Google it again.
Yeah, because so that's the thing, is that if you're a medium-sized company and you get hit with $1 billion verdict, you could be out of business. Right? If you're a gigantic company, yeah, it's going to hurt. Your stock price might dip for a little while if the marketplace, when the marketplace finds out about it. But ultimately, Centripetal probably got, I don't know how big Centripetal is, but they probably got a bigger upside in terms of their value from this than the hit Cisco took. I'm just guessing.
So it says 2018 numbers reported earnings of 0.1 billion with an annual revenue of 49.3 billion. So you have to assume those numbers have gone up. It was a 2.8% increase over 2017. So, but I mean,
even look at their revenues though. If they have 50 billion in revenues and you're paying out 2 billion, that's like what? 4% of your total revenues.
I mean, that's a lot. That can eat into your profit almost entirely, right? In a year.
Hit your bottom line. Yeah, that's pretty ugly. But imagine though, now you're a small or medium-sized company and you're hit with a 10 or 15 or 20, and forget the verdict. Forget that for a moment. You're a small or medium-sized company and you get sued. You don't even get an adverse verdict again.
Well, yeah, imagine it was the other way around.
Yeah, but you get sued. I mean, just getting sued is going to be crippling to you, because even if you win. So I tried a case once with a client. They were sued for false patent marking. Okay. Kind of a weird case. But anyway,
false patent marking.
Yeah, they were alleged to have put patent markings on products and brochures that weren't covering the products. But anyway, they probably spent $500,000 in fees with us. And at the end of it all, we won. We won a jury verdict. And after the summation, my client came up and he gave me this big hug. He was all excited. He kept calling me Tom Cruise. He kept saying, "You're Tom Cruise," from the movie, I think, A Few Good Men. But anyway, Tom had more hair, was way better looking than I was, and believe it or not, was taller.
But you both have the same name.
Yes.
First name.
Yes. At least I had that going for me. But anyway, he was all excited. But then after it kind of settled in, he realized that even though he won, he lost, because we spent like 2 years on this. He was totally distracted, the senior executive we were working with, and they spent like $500,000, and all it enabled them to do was keep doing what they were doing. So if you're a small or medium-sized company, patent infringement can be crippling. So it's even, in some ways, it's more important if you're in that area, that if you're launching new products, you want to make sure you don't infringe patents that are out there wherever you're selling your products. And remember, patents, they cover, there's different patents in different parts of the world. If you have a Chinese patent, you can only infringe it in China. If you have a US patent, you can only infringe it in the US. So you have to do freedom to operate searching wherever you are going to do business, or it could be some pretty ugly responses. It could yield some seriously damaging damages. And it's not just patents. I mean, it's also trademarks. You build a whole thing around your brand, right? You got a new brand. I think we did a podcast once on that young girl that is one of my kids' friends who brand lunacy. And I mean, poor girl starts crying because there's some other company that might have trademark priority over her. That's a 19-year-old girl, but it could happen to anybody, because the damages could be millions with those. And if you're a company that only generates $5, $10, $15, $20 million a year in revenues, that's pretty ugly, right?
Right.
That's painful because you have all your regular legal costs. I mean, you have legal issues all over the place when you're generating any kind of meaningful or hopeful amounts of revenues. You have all kinds of legal issues. You don't want something like this on top of that when there's such an easy solution, which is freedom to operate searching. It's not that expensive as compared to the pain you're going to suffer downstream if you step into one of these landmines.
Well, you just mentioned a second ago a topic for another podcast, which I want to talk about, which is international patent law, and how countries react to other countries' businesses infringing on intellectual property that was originated in their country.
Yeah,
it's been a
do one on that.
Topic on international trade. So I'm just very curious to know.
There's also the issue of patenting and preventing infringement of patents is so expensive. I mean, you need to have a plan. I mean, you can't just go into patenting or even developing new products willy-nilly. Or I should say, no one goes into developing new products willy-nilly. You have to have the same mentality when it comes to patenting. It could be very, very expensive. Even one patent, file it in 10 countries, and you're going to spend a lot of money.
Yeah.
That's for another day. That's definitely.
Yeah. Well, this was an awesome topic. I mean, all kidding aside, I was actually really excited when I read this article because, when is the next time that 1.9 billion is going to be beaten in damages? So
I remember when the first $1 billion verdict.
When was that?
It was a few years ago. There was $1 billion, and it was either a settlement or a verdict. And I thought, wow, $1 billion. That's insane. Yeah. And now there's like a $2 billion. When you throw in the royalties, it's more like 2.5 to 3.5.
Well, we'll come back here in a few years and we'll do another podcast, and we'll reflect back in the days when the biggest damage was only 1.9 billion.
You got it. All right, Ray.
All right, thanks, everyone. Hey, if you enjoyed the podcast, please don't forget to share this on LinkedIn. Leave us a comment. Let us know what you think about this case. And if you're on YouTube, hit the like button and subscribe and hit that bell icon so that you get notifications whenever we post a new video. Thanks, everyone.
Thank you.